afternoon, all. I am very, very sorry for that delay.
No issue. We needed the time. It turned out. Thank you, Your Honor. Professor, anything else on slide 146 before we move on? You were toward the bottom of it, I think.
I think I've said all I intended to say. Thank you.
Okay. Now, on your next slide, you respond and provide an illustrative in connection with Mr. Hutchings' objections to your treatment of forestry expenses. Can you walk us through this, please? Tell us what it shows and just walk us through the details, please.
As we've discussed, Mr. Hutchings raised many specific objections to our nominal calculations. Many, but not all of them, are related to forest management expenses in recent years. And I suggested a few times that we think that our approach is the most appropriate one, but if we were to change it, it would have little impact on the value of annuities under our approach. So I want to offer a demonstration that that's true. So to show the unimportance of the issues related to forest management in recent years, I simply redid all of the calculations for our report again, but this time including only 50% of the expenses in our accounts that were categorized as forest management. We'll recall from earlier in my demonstratives, I think it's slide 45, the colorful blocks picture of the kinds of expense in our accounts. Forest management was the largest category overall, and it was a significant minority of all of the forestry expenses in our accounts. And the issue here is that forest management is a generic category. We don't always know whether that money was spent on forest protection, like disease control, fire management, forest regeneration, and so on. We don't have enough detail to know. So it seems to me, an extreme approach to dealing with that problem would be to cut that amount in half, that only include 50% of those generic forest management expenses into our accounts, only deduct 50% from NCRRs as we proceed through our calculations. Therefore, only 50% of NCRRs would form the basis for annuities for whatever sharing model we prefer.
Sorry, say that again. If you only took 50% of the generic forest management, and what was the 40%? Or do you deduct 50% from the NCRRs? And
Your Honor, I will rely on you. I think I might have said 40% when I meant 50%.
got it.
I think I'm still warming up.
Okay. Okay.
So we're only including 50% at every step of the way then in the calculation. So they will affect all the numbers in some degree. Question is how much. This table tells you how much. This is what we call a sensitivity analysis. It's intended to show whether the results depend in an important way on particular assumptions or not. We don't think we should only include 50%. We just want to know what happens if we do.
Okay.
And within the table on slide 147, the first column of numbers are the numbers we've already talked about. That's our preferred approach. The new column to the right, labeled reduced forest management expense, is what I've talked about. Only include 50% of that generic category after 1945. You can see from the first row, it has a huge impact on the present value of NCRs because it's a big category. In terms of the annuity values presented in rows 3, 4, 5, and 6, I would characterize the impact of that change on the present value of annuities as being extremely small. If annuities were based on our approach, which we call the Vidal-Anderson approach, and 100% of unadjusted NCRs went into the account every year, and we only included 50% of forest management, that would increase the present value of annuities paid by under $34 million. Take it from just under $1 billion to just over $1 billion. There are 3 other rows representing other sharing approaches, all of which would deliver smaller present value of annuities. And the impact on those 3 alternative annuity calculations is, of course, smaller than the 100% one. So even if we took this extreme approach to throwing out forest management expenses, in our view, it would be extreme. The impact on the value of annuities would be small. Once again, the reason is that it would mainly affect the cumulative losses in NCRs. The cumulative losses would become smaller if we did not deduct all of the forest management expense. But almost all of those accrue in the later years, where under our approach, the annuities have already fallen to the $2,000 minimum. It has very little impact on the earlier years when we estimate augmentation would have been paid in substantial amounts.
You also say it's a demonstration of the greater impact of present valuing
In a sense, it,
the NCRRs as opposed to what goes into them.
in a sense, it is. Earlier on, before we talked about risk adjustment at all, I said the earliest years have the greatest leverage in this case because of compound interest. And so that has some influence here as well, in the sense that most of the forest management occurs in the last 50 years of the data, not the first 100 years. All else equal, those years of nominal values have a smaller weight in our accounts or Mr. Hutchings' accounts than the earlier years do. That being said, you can see that even though most of this money is in the last 50 years, it has a big impact, excluding 50%, would have a big impact on our estimated cumulative present value of NCRs given in the first row. NCRs would be now minus 1.7 billion instead of minus 4.6 billion, almost a $3 billion change. So this change is consequential in present value terms for NCRs, but not for annuities, because of our belief that the annuities would not pass the process of augmenting annuities would not pass on those losses to the annuitants.
And finally, on this slide, then going down the first column, we come to a number 386.9 million. And then annuities actually paid 302 point, we'll call it 0.2 million. And so your preferred estimate, your preferred opinion as to what would be payable as annuities is the difference between those two, 85 million, give or take?
That would be compensation. Yes, it would be compensation for annuities not paid that should have been paid according to this hypothetical approach.
On a netted out basis.
Yeah.
And then to the immediate right of that, the arithmetic there shows us the difference using your 50% forestry expenses reduction. And that looks like about 88 million, something like that. Is that right?
Just under 88 million.
Thank you. Your Honor, oh, sorry.
Go ahead.
I want to, I don't have really any more questions. I just want to point out that Professor Smart was asked to rerun each of the 8 tables in the present values report, and they are in an appendix. And I want to check with you to make sure that the hard copy that got to you is the same as what we're working with here, to make sure we don't have, and if we have a mess up in any of the charts, we'll undertake to get that corrected and get the holes punched and everything.
Okay,
So I
so,
just wanna-
so let me know what
It's
I'm looking for.
154, it starts at,
Slide 154.
yes, that's a redone table 1. And
And do you want to look at it to make sure it's what you
I'm gonna
have?
put it up on,
Oh,
I
okay.
suggest I'll put it up on the screen, and if it differs from yours, maybe you could let us know.
It looks the same.
And then the next one, table 2.
Oh, wait, sorry. Could you go back to table 1, please? Did I see an AB? Oh, no, that's correct. Thank you. It's the same, table 2. What am I looking for the change possibly in the numbers?
Oh, anything, really.
There may be the wrong table.
Oh, maybe they're wrong.
Some people got the wrong table.
Okay, mine is the same.
3 down.
Okay, mine is the same.
Slide 157, table 4.
Mine is the same.
Slide 158, table 5.
Thank you. Mine's the same.
Table 6, slide 159.
Thank you. Mine's
7, 160.
hard. That's harder. I'll just pick some rows to compare. All right, it appears mine is the same.
And then slide 61 finally is table 8.
Got it. Thank you.
Thank
All
you.
the same.
Thank you. And again, what those are is a refresher and update of the tables from the present values report. I will ask then. that-
Sorry, I just want to ask you, these demonstratives are an update of
Those tables are.
tables in
Pres-
Exhibit 60?
Yes, present values report. Is it exhibit 60 or 61?
No, that's
61.
61.
Value of the augmentation, Thomas.
Oh, 61. And are they all in one place in Exhibit 61?
No, they're not.
They're throughout.
Exactly all over the place in exhibit 61, but they're in one place, obviously, at the back of the demonstrative.
And then the last. On these slides, which we have just gone through, do you say where they are in the? Sorry. Yeah, do you say where they exist in Exhibit 61? Like, is there a
No,
cross-reference?
we don't. We'll do that for you. I think I mean, there is a list of tables, as I recall, like where the tables are all
Oh,
in order.
I see a reference on the bottom of the page.
Yeah,
Present value report, tables 1 and 4.
and
Okay,
there's a handy collection we put in that they put in here at page 12. So all the tables are in order in the present values report, starting at page 12. So if you want a quick look through just the tables to compare to the demonstrative, they're there.
okay. And where do I find them in the? present
They
value
start
report?
at page 12,
Page 12.
instead of having to read through the body of the report.
page 12, is the present value report the value of the augmentation promise? Okay. My page 12 does not have a list of charts. Oh, here it is.
Yeah, so I'm corrected. The list of tables,
It's on page 5.
yes, and it shows you where the table is in the report.
Got it.
That's,
And those tables, tables 1 to 8, are now all recalculated and they're in the demonstratives.
right. I think at the beginning of his testimony, Professor Smart indicated the various reasons why.
Very good. Thank you.
Thank you. So I would just ask that this be marked as the next numbered exhibit.
The demonstratives.
Yes. And then
All right,
I'll
exhibit
hand the
U.
witness- hand the witness over after that.
All right. Any problems?
I understand my friend would like it marked as a numbered exhibit
Yes.
because the witness, Mr. Smart, testified, to be fair, to a fair bit of new things that are not in his reports,
Yes.
and also elaborated on things that aren't in his reports. And my thought was that it will be helpful to the court to be able to refer to the demonstratives, whether or not plaintiffs agree with what is recorded in here and whether or not Mr. Smart accurately testified to what's in the slide deck, but I don't mind going in with that understanding.
Which is exactly what, I'm not certain.
Okay, that understanding is that
That there are some new things.
yeah, well, there's some new things and some testimony was inconsistent with what's in the new things.
Well, I mean, I can't
Okay.
agree to that characterization. I don't want to
No,
argue,
you don't have to.
I don't want to argue the point right now. I'm just asking that it be marked. We did what your honor asked last week. We sent a letter across indicating anything we thought that was new and so on. You recall that discussion last week?
I do, but I'm not connecting it to how we name the exhibit. So I'll just finish with that.
Sure.
What's the numbers at exhibit 70? Thank you.
Thank you, Brian.
And I'm going to call that the demonstratives of Professor Smart. And I just note, Mr. Schachter, you saying you're noting that there are things in the demonstratives that one might not find in the report.
Yeah, yes, that is correct.
You don't have any problem with that?
I don't have a problem if that's his opinion. I don't agree with it. Or for the most part, I don't agree with it.
Well, it's nice to know that for some parts you do agree with me.
Well, we've indicated if. there's
Okay,
any
you only
whatever.
speak to me.
I only ever do.
Just a reminder. Might be young lawyers watching this. Okay.
Oh, they know.
All right.
Thank you.
Thank you very much.
Professor Smart, you know that I'm Glynis Evans, Counsel for Canada.
Yes.
I just have a couple of questions relating to your report, what we've been calling the nominal values report. It's marked as Exhibit 60. The title is Net Crown Resource-Based Revenues. Do you have that report with you handy there, Exhibit 60?
It's here in this file. Would you like me to go?
Well, there's just a couple paragraphs I'm going to bring up, and I'll have my colleague bring them up on the screen, so that's probably going to be sufficient for you. But the first paragraph I wanted to ask you about was paragraph 36. What I'm getting at, Professor Smart, is your opinion on radio frequency spectrum as a potential source of resource revenues. In paragraph 36 of your report, in noting differences between your approach and the approach of the plaintiff's experts, you say, and here I'm reading from the indented portion, for example, they, the plaintiff's experts, have included revenues from provincial logging tax and from federal telecommunications spectrum auctions. In our opinion, these revenues are not relevant. You maintain that opinion that revenues from federal telecommunications spectrum auctions are not relevant?
To be precise, we don't believe that they are net Crown resource revenues.
For the purposes of the definition provided by the stage one judgment, is that right?
That's what I mean, yes.
So for a little bit more explanation, I'd like to turn to paragraph 66 of that same report. Here you say, the second sentence, the value of spectrum licenses therefore derives from the scarcity created by federal regulation, rather than from the exploitation of natural resources. If there were no regulation, there would be no spectrum revenue. Can you please elaborate on that point, your point about where the value of spectrum licenses derives from?
So economists use the term scarcity rent in the way we have used it in this paragraph. The notion is that the effect of telecommunications regulation for our purposes here is that no one can use spectrum without a license. That is, no one can provide telecommunication services over spectrum in Canada without a license from the federal government to do so. In the absence of those licenses, there would be no payments for the right to do so. In that sense, it flows from the regulation rather than from the natural resource, if any.
So in that same paragraph, you provide an analogy to a driver's license fees. You state, similarly, individuals cannot drive a car in Ontario without a driver's license, but we do not normally associate the driver's license fees with the land over which we drive. Can you please explain this analogy to us?
Well, if I were to do that naturally, Ms. Evans, I would use exactly the same words as you just quoted. The fundamental question here is this a natural resource revenue? It is a revenue of the Crown. Should it be associated with a natural resource? This analogy is to another case of a regulatory revenue, that exists because the government requires one to have a license to operate a car. There is a sense in which natural resources are involved in the exercise of one's rights under that license. They don't seem to us to be intrinsic to the value people are placing on it.
Are you talking about the driver's license in
Yes.
this instance?
So by analogy, we drivers are willing to pay for a driver's license, the amount that the government requires us to do so. In doing so, we are making a certain use of a natural resource because driving takes place over land. But the value of the land is in no economic way, as we understand it, related to the value of the license. Rather, the value of the license comes from the regulation, not from the resource.
And you liken this to the situation with the licensing of radio frequency spectrum to telecommunications companies.
Yes, I think I could make the same statements about a telecommunications company that was using spectrum.
Thank you. Those are all my questions.
Thank you.
I'm gonna be about 5 minutes having material out and getting organized, maybe 3 or 4.
Thank you.
Thank you.
Okay, I think I'm ready to proceed. The first place I'd like to start is that I've prepared a brief compendium for Professor Smart. And with the court's permission, I would like to just mark that Exhibit V as in victory for this examination. And we'll see how much of the documents the Professor Smart is able to identify and help us with. But if we can have that marked as Exhibit V for now.
Thank you.
Okay.
Go ahead.
So Professor Smart. My name is Harley Schachter. We met earlier, I think, outside of court. I've got a couple of questions I have to ask you about some of the things you've testified to. And I thought maybe the first place to start would be right where Canada left off and the analogy of the driver's license involving Spectrum. So let's stick with Spectrum because it's on everyone's mind right now, okay?
Yes,
Okay. So you would agree with me that a driver's license does not give anyone permission to drive onto any public property and set up a mine, does it?
sorry, I didn't hear your words.
A driver's license does not give anyone driving a car permission to drive onto any public property and set up a mine, does it?
And set up a mine. No,
Yeah. Or a forestry company, you just couldn't do that on public land without permission, right?
correct.
And a driver's license fee, you can have a driver's license fee, but it doesn't allow you to ignore toll roads, does it?
Sorry, I don't, who's ignoring toll roads in the example?
I'm asking you whether if having a driver's license fee allows the driver to ignore toll roads.
I think I know what you mean. You'd still have to pay the tolls charged if you decided to drive on the toll road.
Right. Now, a spectrum, would you agree with me, sir, is useless without the land over which the signal is broadcast?
I'm not an expert on the physical technology behind the transmission of radio waves. But you said is useless, so I think there's an economic component to that. I think that the value of spectrum and of telecommunication services is not deeply connected to, and therefore is useful in an economic sense, even abstracting from the land over which those radio waves travel.
I'm going to suggest to you it holds no value save for the customers it can reach and must go across territory. Would you agree with that?
Across territory,
Land, across land.
must go
or water.
across land.
It must travel across land to reach people.
I apologize, sir. I think that that's a question you should ask a physicist. I don't really know where they travel. My sense is it's somewhere else, but I'm really not an expert.
Do you agree that Canada claims to control the use of spectrum within a geographic border?
I don't know Canada's claims in this regard.
Okay. You don't know what happens at the border crossings and whether the licensor in Canada has to pay for use of spectrum when it goes to the United States? You don't know that?
I don't.
Perhaps, sir, I can let you know that I think for the questions that I have for you, you'll probably need the compendium I gave you. You'll probably need the your present value report. your nominal values report. Exhibits 61 and 60. And probably we might get into your SIR replies and your response. So all 5 of your reports. Do you have them with you?
I believe so.
Okay, excellent. So I think the place to start is some, and sorry, final thing we might need is your demonstratives. So the first place to start then is about your expertise. Now, you're not a historian, right?
No,
You're not an ethnohistorian.
no,
You're not a statistician.
no,
You're not an anthropologist.
no,
Have you studied the ways or the culture of the Anishinaabe people in Ontario?
not any more than any intelligent Canadian would seek to do so. No.
How much would an intelligent Canadian seek to do so, sir? I'm not sure I understand that.
I can rephrase if you wish.
Yeah, please.
I'm not an expert on the things that you stated.
Not only you're not an expert, I don't think you've academically studied the Anishinaabe in Ontario, other than I'll give you what you've seen in this court case.
Yes,
Thank you. You're not a lawyer.
no,
You don't claim to have any expertise in what the Anishinaabe were actually thinking in 1850, do you?
I think we make one statement that might be construed as saying we know something about what the Anishinaabe treaty parties were thinking.
And what is that statement? Sorry.
They
I'm
were
not-
uncertain, we state in our present value report, something to the effect of, they were uncertain of the value and they sought to receive a fixed annuity in perpetuity.
Okay, all right, thank you for that. We're going to get to that later. But as long as we're there, would you agree with me that nowhere in the historical record that you read, is there any request by the Anishinaabe for that, what you call a fixed annuity? Would you agree with that?
Our source for the statement I just quoted is almost certainly noted in that report as being the stage 1 reasons for judgment of this court.
Okay, well, we're going to go through that shortly, and I'm going to hope to have you agree with me that you're wrong there, but we're going to need some time to go through that, okay? Now, you also don't claim to have any expertise in what the Crown actors in 1850 were actually thinking, do you?
It depends on what your meaning of actually is, Mr. Schachter. I think that I have greater insights into how government officials today and in the past viewed financial commitments.
Okay, so your opinions about what the Crown and the parties may have thought and believed, can we say is informed by your training and experience as an economist of the late 20th and 21st century, and informed by what you've read about this case?
It's informed by my training as an economist.
That's right. Has
which I
it,
would
was
like
it
to think
informed?
transcends the 20th century.
Sorry?
I'd like to think that some of these ideas transcend the specific historical experience of a person such as myself, who lived in the late 20th and early 21st century. I think there's a higher truth in economics, Mr. Schachter. I think it's a real attempt to understand human values. And I've tried to do that to the extent possible in this case.
Uh-huh. Did you base your opinion in this case on anything you read from Dr. von Gernert?
Yes, I noted in my testimony and in the demonstratives that we relied on one portion of his evidence about the conduct of the Crown in similar matters prior to 1850.
Can you go to tab 3 of the compendium, please? All right, sorry, excuse me, tab 4. Now at tab 4, what we have in front of us is an excerpt of page 7 page 12, just before paragraph 27, you'll see table 1, summary of present value calculations. Do you see that? And there are numbers here. And I want to contrast them very quickly, just for a moment before we come back to it, to the very next page of the compendium, and it's going to be page 18 of the compendium, the very next page. You have your new table 1, correct?
That's right. That looks like precisely the table the court
Right,
just
so
reviewed a
I've
few minutes
just-
ago.
I think I copied it from an email I received. Now, let's start with the new table 1 for a moment. The figure there of minus $4.5 billion for unadjusted NCRRs, you will not find in your work papers that you have provided, will we? Because there was some adjustments made, so we can't look at the work papers to find that.
Yes, I believe you can.
So did you prepare new work papers after May 10th?
Yes, I believe we did.
And have you provided those work papers of May 4th? It's May 14th, right?
What is, no, today is, no, I'm sorry, what are you asking me?
I'm asking, you see, I had thought, and you can correct me if I'm wrong on this. I had thought that your work papers showed that the unadjusted NCRRs are minus 4.8 billion, not minus 4.5 billion. And I'm having trouble reconciling the difference. I know it's only 300 million, but maybe you can help me out.
Well, a famous American politician once said, 1 billion here, 1 billion there. Eventually, you're talking about real money. In Canada, we divide everything by 10. And so I think you're well within your rights to ask about that, Mr. Hutchings. I think you're asking is,
Well, I'm not
Was-
Mr. Hutchings, but
I'm sorry, I've done that before. And I apologize.
it's okay. It's a
So
compliment.
why don't you restate your question, sir, and I'll do my best.
Yeah, I don't understand how you got to minus $4.5 billion and change, if we can call it that. Because when I looked at the work papers, I could only find minus 4.8 billion. And there's got to be a reason for the change. Maybe I'm looking at the wrong set of data. Maybe there's new data. I just want you to tell me so I can find it and work on it tonight and ask you some questions about it.
So I refer you to my demonstratives and the transcript of my testimony on day 1, where I discussed all of these changes, including the final change, which, as I explained to the court, I undertook on the weekend prior to the beginning of my testimony. So, and I apologize to the court for that, but I think it's important to get the numbers right. And so we made a very late change. I don't know about the way in which my work papers get delivered to you, Mr. Schachter.
Okay.
But I think I heard in this court a discussion of a version of May 10th, which was provided to you, and a version of May 13th. If I'm incorrect about that, it's because I don't know what the lawyers do. But I do know that I provided 2 such versions that week around those days in May. And I believe that they found their way to you.
So your recollection then, sir, is that the work papers that you provided to your lawyers that provided it to the court include in the changes that bring us to minus 4.5 billion. Can I have that? That's your understanding. And if it hasn't
I
happened.
mean, I
it's a
want to
mistake.
clarify absolutely. These are not my lawyers, except in the sense that I'm a citizen of the province of Ontario.
Okay,
So,
you could still answer the question though.
well, I was distracted. So could you please pose it again? The question is, what did I do?
Sorry, can I just ask if you?
Yes, sorry. Would you agree with me that you attempted to provide to Ontario Council, whoever they are, work papers that end up with a calculation of minus 4.5 billion for unadjusted NCRRs?
Yes, as I stated.
Okay. But you sitting here today can't tell me which of those papers.
Yes, and I did tell you, sir.
Okay.
The most
but-
recent set of
Sorry,
work
one
papers.
at- just one at a time.
Okay, you did tell me, sir. Go ahead. What did you tell me?
I told you that the most recent set of work papers delivered to you, which as I recall, as discussed in this court, were dated May 13th, are completely consistent with the calculations that I've performed and were fully consistent as well with the discussion we had of those changes during the first day of my testimony.
Thank you, sir. Now let's go back to page 17 of the compendium, and that's your original results. Now, these are the results that you presented in your initial report, right?
Yes,
And after you presented your initial report, there was some back and forth through reports with Mr. Hutchings and Mr. Stig and Professor Stiglitz, right?
all the experts served reply reports of various kinds. Yes,
Right. And as a result of comments made by Mr. Hutchings and Professor Stiglitz, you changed your opinion, correct?
yes, with some reservations, but in the interest of going forward, yes, I agree with that.
And through the process, you made a number of changes independently of comments made by Mr. Hutchings and Professor Stiglitz, and the track changes is a good example, right?
It's- It is the only example I'm aware of. Last weekend, that is now 10 days ago, I decided to make a change in the track share of a couple of railways that we estimate lay inside RST. That was not prompted by anything that Mr. Hutchings said. It's the only example of that that I can think of at the moment.
And it's fair to say, though, that Mr. Hutchings' analysis then resulted in him suggesting to you that there were a number of what he called errors in your calculations and methodology, some of which calculations you accepted and others which you still defend. Is that true?
We agreed with some of his points and we made changes if so. In all cases where we agreed with him, we made changes to our calculations. And if we didn't agree, we didn't.
And the net result of those changes take your unadjusted net crown resource revenues from negative 7.8 billion to approximately negative 4.5 billion. Is that right?
Yes,
Now, there was an addition, a slight change in the geographic area for both you and Mr. Hutchings. You remember that?
yes,
Mr. Hutchings had testified that the change in geographic area resulted in less than a 1% difference in NCRRs. Did you read his testimony about that at all?
I didn't know.
All right, so would I be wrong in suggesting that the changes in geographic area that you recalculated on similarly had a less than 1% difference to your results?
I can't answer in the affirmative because I did not do that calculation.
So who did the calculation?
I didn't do that calculation. I did all of the calculations, of course, but I did not do that specific calculation that you just asked me to speak to.
Are you familiar with the two different maps?
Yes,
As an expert who can help the court on this, can you give the court any guidance at all on the magnitude of the change that
Yes.
I suggested or that Mr. Hutchings testified was less than 1%?
yes, certainly I can. I will if you wish.
Yeah, please.
It was small. I didn't, as in other cases in my examination in chief, I had to say, I believe this, but I have not done that specific calculation. I cannot back this up with a number. So it was my answer to Mr. Schachter's question now. I believe, indeed, I'm very confident that the change in the map was not important. It was not large in terms of its impact, but I never examined the impact of that in isolation of the other changes. So I cannot tell you that it's less than 1%.
Okay.
So the bottom line on that question, the original question is, would I be wrong in suggesting that changes in the geographic area that you've recalculated had a less than 1% difference in your result? And the bottom line is, I don't know the exact number, but it's very small.
Yes.
Could you turn to slide deck 146 of 161?
I'm sorry, was that a reference to my demonstratives?
Yes, your trial demonstrative, slide 146 of 161. Now, in the middle of the page, you said share 100% of NCRRs with annuitants after deducting the cost of risk borne by the Crown. You see those words there?
I do not see those words on slide 156.
No, 146.
Ah.
I'll try. Yeah, my mic is on. 146.
I
I'll
apologize,
speak up
Mr.
and I'm not
Schechter.
yelling
It
at
is
you.
true. I'm sorry. Please finish your sentence.
I will speak up. I'm not yelling at you. I'm just, obviously, the microphone's not working. So we're at 146 of 161.
I was going to say, Mr. Schechter, I do have a hearing problem, but it doesn't relate to the volume at which you speak. I can hear you fine. I don't know about your microphone, but that's not the problem.
Okay,
But it's about enunciation, and I'm doing my best to look at you, which helps, but I also have to look at the page in front of me.
all right. So I will try and enunciate better. In the middle of the page, underneath the second main bullet point, there's 3 smaller bullet points. And it says share of 100% of NCRRs with annuitants. See that paragraph there, or that portion?
Yes, it does not say precisely what you said, and I think the difference of interpretation could be important here.
Okay, what is the difference of interpretation that I'm putting on it?
You said share of 100%, but this is the verb share. We share 100% of NCRRs with annuitants. That's what that statement says.
Okay. So that 100% share in your calculation represents approximately $387 million. Is that right?
Yes.
Now, would it be your opinion that 100% of NCRRs should be paid and shared with the Anishinaabe if the judge decides on a different amount of NCRRs?
We did not reach a specific conclusion about the appropriate share to be shared with the annuitants. We considered a number of different approaches to sharing, and we did not reach a specific conclusion about what the share ought to be.
Well, I guess what you're saying is that that's for the judge to decide what the share should be. I understand that. Is that fair?
Simply stating what we did and did not do, and we did not do what you just suggested that we did. We did.
Okay, I thought that your opinion is that the Anishinaabe should share 100% of NCRRs.
We did not offer that opinion. We did calculate what the value would be if the Anishinaabe had received 100% of risk-adjusted NCRs. That is 100% of NCRs after deducting the cost of risk. We calculated that. In my testimony, you are free to look up the transcript, and tell me exactly what I said. But I did say, we think that that's a possible approach that would make sense to us. After deducting the cost of risk, as I recall this morning, I said, you can imagine that that might be an appropriate approach, but we're not endorsing it or recommending it. We're not of the opinion that one particular sharing approach is what we're here to offer. We're here to offer some calculations based on economic principles.
Well, I guess that's what I'm trying to understand, sir. The economic principle might be that they're entitled to a share of NCRRs. That's one economic principle, wouldn't it be?
I don't think it's an economic principle to, in the absence of other information, I would call that a moral principle.
A moral principle.
I think so. I think each of us can rely on our moral judgments, on our moral valuations, and reach conclusions about that. As an economist, I think my role is somewhat different than either agreeing or disagreeing with the statement you just made, Mr. Scheck.
Would it be fair for me to say that included in your opinion is your moral judgment about what's fair and appropriate?
Could you please repeat the question?
Would you agree with me that your opinion is based on what you consider to be moral or fair?
No, I don't think so. Specifically, I would say, I don't think we ever used either of those words in describing or qualifying the opinions we offered. And I think that we arrived at our opinions on a different basis than I would characterize by those words.
Your opinion, sir, was driven by the result. Is that fair?
What is the result?
The result is $84 million today and $34 million before you made your changes.
And which of those two results do you feel my opinion was
Both
driven
of
by?
them. Your methodology, sir, utilizing risk adjustment and what you identified as the Vidal Anderson approach, which we'll call your approach too. You used those to arrive at an amount you thought was fair.
I might be more open to using that word fair in this context, but only with some qualification, if you'll permit me to add to this.
You're entitled to answer in any responsive way.
Thank you. So we did not use the word fair, but I think I am open to saying risk-adjusted present value strikes us as a fair approach here based on economic principles. So one of the principles of economics is people want to pay as little as possible, but they're willing to pay what they have to get something they value. And so that logic, which I think you don't need a PhD in economics to understand, it certainly informs the way we determine value here. So we think the Crown would like to pay less, but that was willing to pay up to 100% of the value they perceive from NCRs. And so this approach does indeed say that the value of the NCRs that should be used to determine augmentation is 100% of NCRs. So that's fair in the sense that the Crown should have been willing to pay up to 100% of NCRs after deducting all of its costs. It could afford to do that without incurring loss in the sense of the treaty and the Court of Appeal decision. And so to say that they should pay up to that amount strikes us as certainly consistent with the word fair, consistent with the values here,
All I'm trying to understand,
consistent with what the values are in this case.
What I'm trying to get at, sir, is that embedded within your opinion is a consideration of what you felt was appropriate. Would you agree with that?
Did we feel that the numbers we calculated were appropriate? Yes, we did.
Is it fair, sir, that, well, let me try and rephrase the question. Let me go through a series of questions. When you did your work, you were asked initially to arrive at net Crown resource revenues. You remember being asked that by the Crown?
Yes,
Do you remember the Crown asking you to give an opinion about risk adjusted amounts?
yes.
When was that?
For the purposes of this court, we can date it to the instructions letter that Professor Baudouin and I received from council.
Well,
But
maybe
of
we should go to
course-
Go ahead.
Thank you. But of course, we had discussions earlier than that letter in which we explained to Council for Ontario our approach to evaluation in this case. And so while I cannot remember the specific date on which we first informed Council for Ontario of the concept of risk-adjusted present value, it was earlier than the date of the instructions letter.
The instruction letters don't mention anything about risk adjusted value.
Well, why don't, if you want to ask me a question about it, could I please read it?
Yeah, oh, of course. That's why I asked you to have it in front of you. You'll find it at Exhibit F or Exhibit H of either one of your reports. Of the main reports. And take your time.
Got it. Sorry.
Oh, yes.
Okay. Do you want me to repeat the question?
Oh, yes, sorry, please do.
Yes. As I recall the letter, there's nothing in the letter of instructions about risk adjustment. Would you agree with me?
There is a question that was posed to us, which we interpreted as being about risk adjustment.
I'm sorry, sir. I thought you told me. Let's back up. You told me you had a conversation with Council for Ontario and put forward to them this idea of risk adjustment.
Yes,
And that was after you'd done your calculations, arriving at the negative $7.8 billion.
no, sir, I didn't say that, and I don't recall that it was after.
Did you recall when it was then?
I don't. I don't precisely recall.
You did some work. I'm going to suggest to you, sir, that what happened is you did some work on the data and realized that the amount was extremely negative for RST and significantly positive for RHT. And you felt you had to come up with a different theory that was going to sell. Does that sound accurate?
No, Mr. Schechter, it doesn't sound accurate.
Returning to the letter, you said you had a conversation with council about risk adjustment. correct? Before the letter was sent to you, correct?
Yes,
And I said to you that the letter doesn't say anything about risk adjustment, and you were going to tell me where it does.
sure.
Yeah.
May I?
Yeah, no, of course.
So in question 3A, council asked us, what in your opinion is the plaintiff's share of nominal NCRs that is consistent with expectations and understandings, et cetera, and that could have been paid by the Crown without incurring loss? In other words, it asks a question about value. And value for us is construed as risk-adjusted present value.
Okay. And how about what you've referred to as the Vidal Anderson report? Is there anything in the letter there about the Vidal Anderson report?
Well, I think it's also 3A, isn't it, Mr. Schachter?
It's up to you. You can answer the question.
What is the amount that could have been paid by the Crown without incurring loss? Central to our answer to that is the Vidal Anderson approach.
And so in your opinion, sir, this approach that you call the Vidal Anderson approach, which is your approach, allows the Crown to pay without incurring loss. Is that your view of the world?
I'm sorry, if you could ask a shorter question.
Yeah, sure. My understanding of what has happened with the approach that results in $84 million is that the NCRRs are negative $4.5 billion, but yet through economic calculations, $84 million is payable to the plaintiffs. But would you agree with me that Ontario is incurring a loss?
On NCRRs, yes, we believe we have estimated that the Crown incurred a loss.
So even though they're incurring a loss on NCRRs, your interpretation of the implementation of the promise allows for payments to be made.
Yes, as I tried to explain, in the early years, prior to 1960 in particular, we believe the Crown would have received positive NCRs. In our interpretation, there would have been augmentation of the annuities above $4 in many of those years of positive NCRs. Then, beginning around 1960, we have estimated there were persistent losses to the Crown. Under our interpretation, our approach, which we call the Vidal Anderson approach, we don't believe that the Crown would or could have returned to the annuitants and said, sorry, we have to take back the augmentation we gave you in the past. That would be the implication of a joint venture approach. We don't think that's realistic or appropriate. In our approach, the positive augmentation paid in the earlier years in respect of the positive NCRs is never recovered against for the purposes of taking on board the negative NCRs in late years. We don't think that's realistic to think that would happen. And that simple fact explains why NCRs accumulate to a negative present value, but annuities accumulate to a positive present value.
Have you ever considered, in your opinion, the whole of the judgment of the Ontario Court of Appeal? Did you do that?
I don't remember if I've read, I mean, of course, I've read yes, I think it does.
All right, let's turn to that. Can we please go to Compendium tab 1? And we'll do that in a moment. Does the clerk court reporter, you want to break?
We'll go through.
Okay,
Thank you.
so let's turn to compendium tab 1, page 7 at the bottom right-hand corner of the judgment of the Ontario Court of Appeal. I guess it's the court's judgment as amended by the Court of Appeal. And at the top of the page, you'll find paragraph 2B as in Bob.
I'm sorry, I haven't found it.
Yeah.
Sorry. Page, which page is it?
It's the bottom right-hand side, there's page numbers for the compendium for the whole document. It's page 7, and at the top in the middle, it's page 9.
Yeah.
And it starts with the words "B, the treaty reflects."
Yes, thank you. I've got it.
Okay. So one of the things that, and if, let's go over back to page 6, the previous page. Says the court adjudges and declares that the principles governing the treaty parties' implementation of the annuity provisions are to accord with this court's determinations that, and then it includes A and B, and we'll get to those in a moment. But am I to understand, sir, that the opinions offered to the court by you are your best attempt at complying with the this judgment?
Yes,
And is it your view that your methodology that you used and the conclusions that you arrived at are consistent with this judgment?
yes,
Let's take a look at paragraph 2A, and I have some questions for you. 2A talks about the Robinson Superior Treaty was negotiated by the treaty parties around the Anishinaabe Council Fire at Bawating, Sault Ste. Marie, as a renewal of the ongoing relationship between the Anishinaabe and the Crown, grounded in the Covenant Chain Alliance. And I'm going to stop there. Do you know what the Covenant Chain Alliance is?
no,
Did you read this and think maybe you should ask in order to have a sense as to what the Court of Appeal intended?
I can't recall what I thought at that moment.
And as a basis for continuing a mutually respectful and beneficial relationship going into the future? See that there?
Yes,
And you understand that the court talks about a future relationship, not just a one-time purchase and sale relationship. You appreciate that?
could I have a moment to review the
yeah.
text?
Yeah, absolutely.
You asked me whether I interpreted paragraph 2A of the court's decision as being in respect of the future. Is that correct?
A future ongoing relationship and not a one-time purchase.
I see no reference to a purchase in the paragraph. I do see a reference to a mutually respectful and beneficial relationship going into the future.
And it's your opinion that your methodology and your results achieve that?
I think it's a basis for such a relationship. It wouldn't be the sum total of everything that would go into such a relationship between the treaty parties.
How long does a treaty last? Do you know?
It depends on the treaty.
Long does an Indian treaty last? Have you any idea?
Yes,
Okay, how long?
they're perpetual
Yes,
commitments.
and this perpetual commitment is about the future. It involves the future, yes.
Parties in 1850 embarked on a relationship, including some contingent payment arrangements as interpreted by this court in the present day. that extended into the future well after 1850. I fully agree with you.
And that would include today as well, wouldn't it?
Yes.
And it would include 2025, wouldn't it?
What would? What
The
precisely? would?
the treaty relationship.
Yes,
And the beneficial and respectful aspect of the treaty would continue in 2025. And it would continue until 2050. Yes, you agree?
I would hope so.
Yes. Now, would you agree with me, sir, that your risk adjustment methodology effectively asks the question, what would someone have paid for an asset in 1850?
Yes, it is based on an 1850 valuation perspective.
Correct. And the result of your risk adjustment approach is that beginning in 2019, the share of the Anishinaabe is 1% or less. Correct?
It does not begin in 2019. It's on the same order as that, even in prior years, to be clear. We got near to 1% earlier than 2019. And what was absent from your question was a question of, was the question of a share of what? So it's the share of NCRs, whether positive or negative, but in our estimation, they are negative.
And in next year, their share goes down by 2.7% of whatever the percentage was in the previous year, right?
Yes,
And then in the year after that, it goes down another 2.7% on what it was the previous year.
I want to clarify, this is important, that there's a distinction between percent changes and percentage point changes. And so the share, as we have agreed in 2019, is around 1%. When you, Mr. Schachter, say, does it go down 2.7%? We do not mean it goes from 1% to minus 1.7%. We mean it changes from 1% to something very close to 1% again. Please go ahead.
No, it goes down, I guess another way of putting it, it would be 97.3% of 1%, right?
Assuming we started from exactly 1%.
1%.
Yes,
Yes.
Good.
And then the year after that, it goes down by 2.7% of 97.3%, correct?
that would be the logical extension of what we did, but we did not do that. We calculated the risk adjusted present value for the years from 1850 to 2019, and we stopped in 2019.
Why didn't you stop in 1950?
We stopped in 2019 by agreement with the other economic experts, is we started our work at the beginning of 2020.
All right. Your model for the future relegates the Anishinaabe to less than 1% share, eventually reducing, I guess it'll never get to zero because of the way math works. But it's going to be somewhere between 0 and 1% for infinity, right?
If our approach were to be extended into years after 2019 with no further changes, then I agree. It would imply that the share of NCRs, whether positive or as we believe negative, that form the basis for the annuity augmentation would be 1% or less.
Are you suggesting to me, sir, that your methodology does not require the judge or the court accepting that in future years, they're entitled to less than 1% share, whatever it is?
This is an important question, sir. Could I ask you just to repeat it? I would hate to be answering the wrong one.
Are you, maybe I'll try and rephrase it a bit. Are you suggesting that the model that you are suggesting that the court adopt gives to the Anishinaabe something different than between 0 and 1% for the next infinity?
It does not have any recommendation for the future. My own recommendation as an economist that works on government policy issues, including resource revenue sharing issues across this country, is that going forward, a different arrangement might be more politically successful than the past arrangement we consider most consistent with the public finance principles of 1850. We live today in the present. We take a different approach to these issues than the parties in 1850 did. There are other ways to approach the sharing of resource revenues among interested parties. I regard that as fundamentally a choice that must involve more than simply economic principles, political principles as well. And certainly everything that we've said is, in my mind, entirely consistent with a different model of resource revenue sharing being adopted in future after the issues that were raised in this legal action are resolved.
So let me try and understand this, sir. For the period 1850 to 2019 brought forward to 2020, you can do you can bring your economic expertise to provide the court with guidance about what was intended in 1850. Is that right?
We capture notions of value from an 1850 perspective, which I believe describe the fundamental economics that those parties were considering in
So
1850.
you bring your economic expertise to this court and you're going to tell the court your best opinion about what economics says about sharing between 1850 and 2019.
No, I'm sorry, I disagree.
Oh, you're not doing that.
We don't offer an opinion about the right share.
No, perhaps I didn't make myself clear. You're offering an opinion based on economic analysis of what the appropriate share is. I see the final numbers. That's what, let's call that the appropriate share, or the share that you opine on. What would you prefer?
Well, there are many such numbers. We should indicate to you that we do not opine on the appropriate share.
You opine on, you don't,
I don't believe we do.
okay? Do you opine on a final number?
We have offered several numbers, which are bottom line numbers, in the sense that they represent the present value of annuities computed from our framework using different shares. We have said that our preferred model is the one that is based on risk-adjusted present value. And let me be clear why it's preferred, if I may. It's not because of any moral judgment that that is the right answer to this question, but rather the economic judgment that the value should be considered are the values from an 1850 perspective in a way that's consistent with the expectations and understandings of treaty parties as we may construe them today, and adjusting for the inherent uncertainty of those expectations in 1850.
Yeah.
Therefore, we view values of annuities augmented based on risk-adjusted present value concepts as our preferred approach to doing this, but we have produced bottom line numbers representing the value under fixed percentage sharing rules. I will point out that even our risk-adjusted present value approach could be computed with everything the same as I've described it, but only a certain percentage of NCRs being included in the account on a risk-adjusted basis. So we could, for example, have presented an 84% sharing rule, risk-adjusted present value basis for Vidal Anderson augmented annuities, if the court would have permitted me to go on even longer than I did. We did not present that. One may easily calculate the implications of doing that as well. However, we regard in this case is entirely consistent with our understanding as economists of the term without incurring loss to say that after the Crown is compensated for the cost of the risk that it bore, it would be consistent with our principles to conclude that the Crown should share 100% of the remaining NCRs. And that's what we do in that case. So we do
Yeah.
not opine on the moral basis for that, but we do go so far as to say it's fully consistent with the economic principles that we advance. And it seems to be consistent with the treaty's requirement that the payments be made to the extent the Crown may do so without incurring loss.
Are you able, sir, to give me an opinion as to the nominal annual NCRRs that is consistent with the expectations and understanding of the treaty parties as seen in the historical records, and that could be paid by the Crown without incurring loss for the year 2025?
No,
Is it because you don't have the data?
yes,
But if you had the data, you'd be able to present an economic, bring your economic expertise to provide, allow the court to have some guidance about what to do about the future. That's what my question's about the future.
if I had the data, it would no longer be the future, it would be the past.
Yeah, I wonder if you're being a bit pedantic, but let me try it this way. I want to know if you can help the court with the question, what does the relationship, sharing relationship look in the future? And the reason why I'm asking the question is because you provided the court with your economic opinion about the past, correct?
Yes,
And you brought economic expertise to your opinion about the plaintiff's share in the past based on your understanding of expectations and understandings in 1850, right?
yes,
Can you provide any assistance to the court about what the court should do about the future?
we were not asked to provide an opinion on anything after 2019, nowhere in our report did we offer such an opinion. I offered a comment a few minutes ago in response to another version of this question.
Well,
But-
your answer, oh, sorry, go ahead. Did you want to finish? Was there something you wanted to finish?
Trying to
You
remember.
said you answered, you were about to tell me that you had answered a similar type of question earlier.
Yes,
Is there something you wanted to say about that?
I'm afraid I don't recall, forgive me.
Sure.
It's true that I don't recall how I was going to finish that sentence.
Yes, sir.
Excuse me, it might assist the witness if he could have the transcript right back to him of what his answer was up before he was interrupted by Mr. Chapman.
Only if you want. You want that?
Do you want it? No, I don't feel the need for it,
Okay.
Your Honor. It may depend on the next question Mr. Schechter asks, of course.
Professor Smart. There are economic principles that helped you provide an opinion to the court about what the compensation should be up to 2019 brought forward to 2020, right?
Yes,
Are there any economic principles that you can see that would help you give an opinion to the court or some help to the court about what should happen in the future?
yes. I want to start by saying again, if I may, that this is in no way based on the report or the instructions we received from Council for Ontario to prepare that report. We did not offer any opinion on that. If you're asking me my opinion as an economist today, rather than as the author, co-author of those reports with Professor Bodway, I can give a similar answer to what I gave before.
And so as an economist, what is that answer?
So I think that different sharing principles might apply beginning, say, in the year 2024, because that's the fiscal year we're in, than applied in 1850. I think that the Crown probably operates today under other principles than it did in 1850, and might take certain actions in the spirit of reconciliation in 2024 that it would not in 1850. I also think that there's an important economic point, which is that any arrangements made around sharing now would affect the decisions of agents in the future. Agents is our term for people who make decisions. And that thinking about the appropriate arrangements for the future as an economist, I would recommend that the Crown and indeed all parties to those discussions think about how their decisions over sharing might affect the decisions of others over decisions of whether to invest in resource extraction and indeed the decisions of future Crown actors over how much to invest in resource activities and how much to take in resource activities, resource rents in the form of Crown revenue. So all of the decisions around sharing that were made today on a going forward basis could have those knock-on effects or secondary effects on decisions in the future. When we look backwards, however, those issues do not arise. Any decision this court, for example, were to make about what sharing should have been in the year 1900 cannot affect the decisions of Crown actors or of others who existed in 1900. And so, of course, I would recommend that different rules be applied going forward for those reasons.
Would you agree with me, sir, that the process contemplated by the Crown, by the judgment, and you're aware that the judgment requires the Crown to engage in a process of discussion with the Anishinaabe, existed in 1850, that obligation? You understand that?
If you're asking me to speak to a particular element of the court's decision at stage one, I would ask you to give me the chance to read it.
Okay, let's turn to it, sure. So at page 6 of the compendium, at paragraph 1 of the judgment, B, to fulfill its obligation in A, and that's the obligation on the interpretation of the treaty from 1850. To fulfill its obligation, the Crown, Roman numeral 1, is required to periodically engage in a process in consultation with the First Nation parties to determine the amount of the net Crown resource-based revenues. You see that?
Yes.
And that's precisely what you're talking about then, is that that consultation process is needed.
Well, I didn't speak to the consultation process. I did speak to the recommendations that I would make as an economist to anybody taking part in such a consultation, I guess.
Well, as an economist, you're of the view that there should be a discussion, I called it a discussion or consultation, to determine the amount of net Crown resource-based revenues, because in your opinion, it could affect other people, I thought you said. The use of the resources.
What I was speaking to before is really a distinct issue from paragraph 1B1, Roman 1 of the.
Would you agree with me, sir, that the effect, the concern that you have about the future being what will the effect be on resource users and resource extraction, that not a new feature of 2024. That same problem presented in 2018, did it not?
Which problem?
You identified a problem, sir, that there should be, based on economic principles, you said, there should be a process of engagement, can we call it? Consultation, discussion between the Anishinaabe and the Crown to find out, rework the arrangement, renew the arrangement. Those are my words.
Yeah.
Is that fair that that you wanted to have some sort of, you were recommending some sort of discussion process?
No, Mr. Schechter, I'm sorry that if I misled you. I am not here to reach conclusions on such broad and important issues as the one you've just described. What I spoke to before was really conditional on any kind of, you asked me, right? I answered your question. You asked me, well, what should the court say about the future? And my answer was, well, I imagine, speaking as an economist who's worked on revenue sharing among governments in the past, I recommend that all parties in thinking about what they would propose for the future should think about these issues, and that the future need not be the same as the arrangements in the past. That's all I said. I didn't
Right,
recommend that
okay.
any process happens, and I would not agree that paragraph 1B Roman 1 of the decision is speaking to the kind of consultation process that you're describing.
That's something different in your view.
Well, to be clear, it's not important that I interpret this paragraph for the purposes of dealing with my instructions. And yet I'll just point out that if you want to ask me more about that paragraph, I will want to reflect on it more.
Well, I've only got a couple more questions today. Why don't we go over to page 7? Page 7 of tab 1, the decision. And the judgment reads that the treaty reflects the parties' common intention that their agreement was to allow both the Anishinaabe and the Crown to realize the future opportunities and potential of the treaty territory in a manner consistent with the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, and the intention of the Crown to act honorably with justice or fairness and with liberality or benevolence. See that?
Yes,
Did you factor all of those considerations into your opinion?
we did factor all of those into our thinking about the opinion that we wanted to offer.
All right, and I'd like to start with reciprocity as a principle. Can you tell me what reciprocity is?
Well, I can't, because it doesn't come up in our expert report. And as I was at pains to say earlier, I do not feel myself sufficiently expert in Anishinaabe principles in order to offer the court an opinion on what form of sharing is consistent with any Anishinaabe principles, including the principle of reciprocity. I'm
And
not
inclu-
here to do that.
Including the principle of renewal, responsibility, and respect as well? Same answer for that as well?
Same answer.
Thank you. Perhaps we can leave that for until tomorrow, then it would be a good time to break.
Let me just catch up for a moment, please. Okay. So we'll break for the day.
Yes,
Um, Are we good for a start at 10?
10. Yes, I think so.
And how is we can go off record. How is the temperature?